Hey everybody, it's Christopher Small from CMS Law Firm. We do estate planning, we do probate, we do it well. Today I want to talk to you about putting your kids or anybody else on the deed to your real estate and why you should not do that, why it's a bad idea. Before I get there though, if this discussion sparks more questions or you need help with anything related to estate planning or probate, please go to estatemeeting.com. You can set up a time to talk to me over the phone or in person for free. estatemeeting.com. All right. So I get this question a lot, and so I want to just talk about it again. I think I probably talked about it before, and it's a common question, I think, because it seems like a good solution to a problem. You own some real estate as a person, and you want to add your child or somebody else to the deed for several different reasons. Reason number one might be that you think you want to give them some control. You want them to help you with the property. Reason number two might be that you want to the property just to transfer to them when you are gone. Those are the two main reasons. If there are other reasons, that's fine. I think my discussion here will probably take care of all of these reasons, but it's really a bad idea for several reasons. The first reason is practical. Okay, when you transfer your property, even half of it, to anyone, they become the owner of that half, and they can do whatever they want with it. That means they can give it away to somebody else. They can sell it or try to sell it while you're still alive. They can encumber it so they can get loans on it. If they are ever involved in bankruptcy or in a lawsuit or anything else like that, then that can become subject to creditors and things like that, particularly if it's not their residence. So there can be a bunch of different sort of real world problems that arise when you do something like this. The other thing to remember is that when you gift the property, which is what this would be, to and by the way, you can do it two ways. You can gift it and you won't have to pay any excise taxes on the gift, or you can sell it to them. If you sell it, though, you're going to have to pay transfer taxes when you transfer the title over to them. But what you have to remember is when this, if you gift the property to them, if you just add them to the property, then you are going to lose what's called a step up in basis on at least that portion of the property that you give to them. So for example, if you bought a property for $100,000 20 years ago, and now it's worth $1 million, if you would sell that property while you were alive, you would have to pay tax on that $900,000 of gain. If you give half of your property to anybody, then they are going to take that portion of the property with the same tax basis that you did, which is $100,000. When they sell, or when you sell in the future, then they're going to have to pay capital gains tax on all that gain over $100,000 or over $50,000. They're half of the purchase. They're half of the value of the property. If you die and transfer the property to someone, they get a complete step up in basis, so they have to pay zero tax. So if you bought the property for $100,000 and now it's worth $1 million when you die, whoever you give that property to is going to take that property with a tax basis of $1 million. So if they sell that property, they're going to owe zero tax. So that's another thing to consider. And the last thing to consider is that if you want to accomplish some of the things that I mentioned earlier, there are ways to do that don't involve retitling the property in someone else's name. First of all, if you want somebody to be able to sort of step into your shoes and take care of your business and do things for you, then you can execute a power of attorney that will allow them to do that. If you only want them to do specific things, you can also issue a limited power of attorney for the specific role, the specific things that you need to have done. That's number one. That will not get over the problem, though, of transferring the property after you die. Like a lot of people do this because they think it'll help them avoid probate, and it will, sort of, but there's a better way. First of all, you could use what's called a transfer on death deed. In Washington State, there's this new little vehicle. It's called a transfer on death deed. It's basically a document that you record at the county recorder's office, and it says, when I die, I want my property to go here. When you die, that person just records the death certificate, and automatically that property is transferred to them with a full step up in basis. The other thing that you can do if you want to avoid probate is you can put the property into a trust. If you want to know more about trusts, then you can go talk to me, estatemeeting.com, and do that, right? But the bottom line is the point of this video, what I'm trying to get you to do is not transfer your property to your children or to other people for these reasons, just to avoid probate or these things. There are much better solutions, and solutions with basically limited or no downside. All right. Before we go though, before you take any action on something like this, I'd rather that you call me and we talk about it, even if I can't help you, so that you make sure that you are doing the right thing. Okay. If you would like to talk to me, you can schedule a time. It's very easy. It's free. You can do it in person or over the phone. Go to estatemeeting.com. My calendar pops up. You just pick a time and we chat. Okay? So estatemeeting.com. Thank you so much for your time. Once again, I'm Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. If you like this video, if you know anybody that needs to see it, share it with them. If you have a question or comment, leave it below. And I will probably be here talking to you again tomorrow.